Welcome everyone. This is Priyanshu Danu, a first year law student pursuing BSc LLB at National Law Institute University Bhopal, and I'm currently interning at Sejpal Associates Advocates in Ahmedabad, Gujarat. Today, I'll be discussing a landmark judgment of the Honorable Supreme Court of India, which revolves around the fundamental right to freedom of speech and expression guaranteed under Article 19(1)(a) of the Indian Constitution. This is the case of Shreya Singhal versus Union of India, also known as the Shreya Singhal case. In this judgment, the two-judge bench of J. Chalameshwan and R. F. Nariman struck down the Section 66A of the Information Technology Act 2000 and Section 118D of the Kerala Police Act in its entirety on the grounds that it was violative of provision of Article 19(1)(a). Shreya Singhal versus Union of India is a landmark case in the Indian legal system that revolves around the fundamental right to freedom of speech and expression guaranteed by the Indian Constitution. The case involved multiple writ petitions filed in the Supreme Court of India challenging provisions of the Information Technology Act and the Kerala Police Act that were perceived as infringing upon the right to free speech. The Supreme Court declared Section 66A of the Information Technology Act as unconstitutional. This provision allowed for the arrest of individuals for posting offensive or menacing content on the internet. The court held that Section 66A was vague, overbroad, and allowed for the suppression of legitimate expression. This decision was significant as it recognized the potential for abuse and misuse of such provisions, which could curtail freedom of speech and expression. While the court affirmed the constitutional validity of Section 69A and 79 of the Information Technology Act, it provided guidelines to prevent abuse of power. Section 69A empowered the government to block certain online content for reasons of public order and national security, while Section 79 imposed liability on intermediaries for hosting or publishing objectionable content. The court emphasized the importance of protecting freedom of speech and expression on the internet, stating that any restriction on this right must meet the standards of necessity and proportionality. The judgment in the Shreya Singhal case had a significant impact of Indian law and set an important precedent for the protection of freedom of speech and expression in the digital age. It highlighted the need to balance the right to free speech with legitimate state interests while emphasizing the importance of upholding democratic values and ensuring that restrictions are reasonable and necessary. The case emphasized the role of the judiciary in safeguarding individual rights and ensuring the integrity of the democratic process. Moving on to the facts of the case. In 2012, two girls named Shaheen Dada and Renu Srinivasan were arrested by the Mumbai police for expressing their discontent on Facebook regarding a bandh declared by the political party Shiv Sena following the death of the leader Bal Thackeray. One girl posted a critical statement about the bandh while the other girl liked the post. The police took action against them under Section 66A of the Information and Technology Act 2000, which dealt with sending offensive messages through communication services. The arrests sparked public outrage and media attention, with many arguing that Section 66A violated the right to freedom of speech and expression guaranteed under Article 19(1)(a) of the Indian Constitution. Section 66A allowed the police to arrest individuals without a warrant for posting objectionable content online, leading to the arrest of innocent people who expressed dissenting political views. In response to the protests, the Union Government of India issued a notice in 2013 stating that no individual should be arrested under Section 66A without the prior approval of a senior police officer. Several petitions challenging the validity of Section 66A were filed before the Supreme Court of India, which consolidated them into a single public interest litigation named Shreya Singhal versus Union of India. The Supreme Court, in an interim measure, prohibited arrests under Section 66A without the authorization of senior police officers. Subsequently, the court addressed the constitutional validity of the challenged provisions in the case. Moving on to the sections that were contested. Section 66A of the Information Technology Act of 2000 made it a punishable offense for any person to send offensive information using a computer or any other electronic device. The provision also made it punishable for a person to send information that they believed to be false, Even sending emails for causing annoyance, inconvenience, or to deceive or mislead the recipient about the origin of the message was punishable under this section. Further, it prescribed 3 years imprisonment if a social media message caused annoyance or was found grossly offensive. Section 79 in the Information Technology Act 2000 says that any social media intermediary will not be in the radar of legal action for any third party information, data, or communication link made available or hosted by him. It further reveals that the available protection shall be applicable if the sent intermediary does not in any way initiate the transmission of the message in question, select the receiver of the transmitted message, and do not modify any information contained in the transmission. Section 69A enables the center to ask any agency of the government or any intermediary to block access to the public of any information generated, transmitted, received, or stored or hosted on any computer resource. Any such request for blocking access must be based on reasons given in writing. Social media intermediaries failing to comply with the rules and regulations are liable to be monetarily penalized along with an imprisonment term which may be extended up to 7 years. Section 118D of Kerala Police Act says that any person who causes annoyance to any person in an indecent manner by statements or verbal or comments or telephone calls or calls of any type or by chasing or sending messages or mails by any means shall be punishable with imprisonment for a term which may extend to 3 years or with fine not exceeding 10,000 or with both. The main issues that were discussed in this case were whether Section 66A of IT Act 2000 is curtailing the right to speech and expression, and whether Section 66A of IIT Act 2000 is saved under Article 19(2). Further, moving to the arguments by the petitioner's side. The main argument put forth by the petitioners in the case of Shreya Singhal versus Union of India was that Section 66A of the Information Technology Act was unconstitutional as it violated the right to freedom of speech and expression guaranteed under Article 19(1)(a) of the Indian Constitution. They contended that words such as annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred, or ill will mentioned in the section fell outside the scope of reasonable restriction outlined in Article 19(2) of the Constitution. Additionally, the petitioners argued that the provisions of Section 66A were vague and uncertain, leading to the charging of innocent individuals. They further contended that the enforcement of Section 66A would result in a form of censorship, thereby chilling the freedom of speech and expression and impeding the viewer's right to access diverse points of view. The petitioner also claimed that Section 66A discriminated against Internet users, violating Articles 14 and 21 of the Constitution. They argued that the section suffered from procedural unreasonableness and lacked a distinction between the Internet and other forms of communication. Further, the petitioners also challenged the constitutionality of Section 69A of the Information Technology Act and the Information Technology Rules 2009. They argued that these provisions failed to provide pre-decisional hearings to the originators of the information and lacked the procedural safeguards available in the Code of Criminal Procedure. Furthermore, the petitioners contended that Section 79 of the IT Act and the Information Technology Rules 2011 were vague, overbroad, and violated the reasonable restrictions under Article 19(2). Specific criticism were directed towards Rules 32, 34, and Section 79(3)(b) of the Act. Lastly, the petitioners challenged the constitutionality of Section 118D of the Kerala Police Act, asserting that it violated the rights guaranteed under Article 19(1)(a) and fell outside the scope of Article 19(2) of the Indian Constitution. They also questioned the legislative competence of the Kerala government to enact such a provision. In summary, the petitioners argued that the various provisions of the Information Technology Act and the related rules infringed upon the fundamental right to freedom of speech and expression, lacked clarity, and lacked procedural safeguards, making them unconstitutional. Moving on to the arguments from the respondent side, the learned's additional Solicitor General effectively defended the constitutionality of Section 66A of the Information Technology Act 2000. The Council argued that the legislature has the authority to enact laws and the court should only intervene if a statute violates the provisions of the Constitution. They contended that the possibility of abuse of a provision is not sufficient grounds for declaring it invalid. The Council also pointed out that the use of loose language in Section 66A is intended to protect individuals from violations committed through communication mediums. They further argued that the vagueness alone cannot render an entire statute unconstitutional if it falls within the legislative competence and is non arbitrary. Additionally, they asserted that the unique nature of the Internet justifies applying relaxed standards for reasonable restrictions on speech made through this medium. The Council assured the court that the government is committed to preserving free speech and would not misuse statutes or provision to suppress it. They also suggested that if the court finds fault within a specific provision, the doctrine of severability could be employed to save certain parts of the section. Regarding Section 79 of the Information Technology Act 2000 and the Information Technology Rules 2011, the additional Solicitor General defended their validity. They argued that it is a common practice worldwide for intermediaries to have user agreements similar to Rule 3.2, granting them discretion to remove information based on their own judgment. After hearing the arguments from the petitioners and the respondent, the two-judge bench of J. Chalameshwar and R. F. Nariman struck down the Section 66A of the Information Technology Act 2000 in its entirety on the grounds that it is violative of provisions of Article 19(1)A and not saved under Article 19(2). The court upheld the constitutional validity of Section 69A of the Information Technology Act 2000 and the Information Technology Rules 2009. Further, Honorable Supreme Court declared Section 79 as constitutionally valid but subject to Section 79(3)(b being read down to mean that an intermediary, upon receiving actual knowledge from a court order or on being notified by the appropriate government or its agency that unlawful acts relatable to Article 19(2) are going to be committed, then fails to expeditiously remove or disable access to such material. Similarly, the Information Technology Intermediary Guidelines Rules 2011 has been held valid subject to Rule 3, Subrule 4. Section 118D of the Kerala Police Act was also struck down by the court on the grounds that it is violative of the provisions of Article 19(1)A and not abiding the reasonable restrictions mentioned in Article 19(2) of the Constitution of India. Further, it has been held that this act will fall within Entry 1 List 3, which speaks of criminal law, and would thus be within the competence of the state legislature in any case. Further, moving on to the logical reasoning behind the judgment. Article 19(1)A of the Indian Constitution guarantees and protects the right to freedom of speech and expression. Government policies and initiatives are no exception to it. In many landmark judgments, like the case of Ramesh Thapar versus State of Madras, the Honorable Supreme Court said freedom of speech lay at the foundation of all democratic organizations. Further, in the case of Bennett Coleman versus Union of India, it was held that freedom of speech and press is the ark of the covenant of democracy because public criticism is essential to the working of its institutions. Article 19(2) allows the government to impose reasonable restrictions on the rights under Article 19(1)A. The Supreme Court in the current case found that 66A is capable to limit all forms of internet connections as it doesn't make any distinctions between mere discussion or advocacy of a particular point of view, which may be annoying or inconvenient or grossly offensive to some. An incitement by such words lead to an imminent casual connection with public disorder, security of state, etc. Therefore, as Section 66A was arbitrary and vague in nature, it was declared unconstitutional by the Supreme Court in the current case of Shreya Singhal versus Union of India. The judgment given by Justice J. Chalameshwar and R. F. Nariman in the case of Shreya Singhal versus Union of India is a landmark one in Indian legal history. In this case, we can definitely say that the Honorable Supreme Court of India took a remarkable step in quashing Section 66A of the Information Technology Act 2000, which is essentially a censorship act. While invalidating Section 66A in the case of Shreya Singhal versus Union of India, the Supreme Court not only gave a fresh lease on life to freedom of speech and expression in India, but while deciding this landmark case of Shreya Singhal versus Union of India, the Honorable Apex Court has also successfully discharged its responsibility of being a constitutional court for Indian citizens. In this case, doctrine of reasonable restriction and doctrine of vagueness are mainly used in order to analyze whether the provisions are constitutionally valid or not. With regards to the doctrine of severability, this case is a perfect and clear example. It is one of the landmark and rare judgments where the apex court has adopted the extreme steps of declaring a censorship act which was enacted by the parliament as unconstitutional. The court has struck down the unconstitutional provision which tried to silence the voice of common people. Therefore, state must take effective actions without merely providing circulars to the higher officials. Then only this landmark judgment can be practical and fruitful. Even thousands of culprits can escape, but one innocent person should not be punished. As a whole, this is one of the enlightening cases, and this landmark judgment is really appreciable. And most importantly, it upholds and increases the people's trust on judiciary. This was all about the case of Shreya Singhal versus Union of India, a case that upheld the importance of freedom of speech and expression in a democracy. Thank you everyone for watching this video, and if you found this video informative, please make sure to like, comment and share this video. Also, make sure to subscribe. Thank you everyone.